KDWN News Time, 9 o'clock. For 20 years, Brian A. Lowe and Associates have helped Las Vegas locals protect against foreclosure and file Chapter 7 and 13 bankruptcy. If you're in trouble, call 259-0002. Good morning. I'm John Schaefer with this hour's top stories. The Marine Corps says 7 Marines have been killed in a training accident at the Hawthorne Army Depot about 140 miles southeast of Reno. The Corps says in a statement that the accident last night also injured several with the 2nd Marine Division. The cause is under investigation. The Hawthorne Army Depot stores and disposes of ammunition. You may have noticed at the pump, gas prices are falling. In the past week, prices here in Las Vegas dropped 2.7 cents to $3.78 per gallon. Prices in Vegas are 9.8 cents per gallon lower than they were this time last year, but 12.5 cents higher than they were 1 month ago. It was 10 years ago today that the U.S. and allies began the Iraq War.
March 19, 2003.
On my orders,
President George W. Bush announcing the start of the war that toppled Saddam Hussein. But there was trouble ahead.
We went in with some complete misconceptions of what Iraq was about.
Iraq today is free of a dictator, but there's still violence, political issues, and corruption. Former U.S. Ambassador Christopher Hill does not want to answer the question many people have.
I'm not going to say it wasn't worth it, but I am going to say this was a very tough proposition.
Sagar Meghani at the Pentagon.
Republican State Senator Michael Roberson has introduced a bill to do away with the Las Vegas Township Constable's Office. The proposal introduced yesterday would give the sheriff the responsibilities of the constable, which includes serving paperwork and carrying out evictions. The constable's office has faced scrutiny since John Bonaventura was elected in 2010. Clark County commissioners will also take up the issue of abolishing the constable's office at their meeting today. Pope Francis has begun his tenure as leader of the world's Catholics with an installation mass in St. Peter's Square.
He arrived in an open Pope-mobile, no bulletproof glass, circling the square for more than 15 minutes as the faithful cheered and waved flags. Then he led High Mass in the sun-drenched square, accepting the fisherman's ring and lamb's wool stole, making him shepherd of a global flock of 1.2 billion. And in his homily, Francis said all of God's creation needs protection, from a threatened environment to the humblest of his children, especially the poor and the weak. Mark Smith, Vatican City.
The financial report brought to you by Las Vegas jewelry and coin buyers. On Wall Street, the Dow is down 33 points. Gold is at $16.13 an ounce, silver $28.99, platinum $15.61, and palladium $747.50. For questions about your precious metal or coins, call 547-1670. The news brought to you by Valvoline Max Life. After 75,000 miles, switch to Valvoline Max Life motor oil, specially formulated to help fight engine breakdown in higher mileage cars. Max Life, because there's a lot of car left in your car. It's 9:03. Here's Mitch Kelly with the latest from the KDON 1 Nevada Credit Union Traffic Center.
This report brought to you by Constant Contact. Want your marketing plan to be as stress-free as the open road? Email marketing from Constant Contact's an easy-to-use tool that helps you to reach your customers in a place they're checking every day, their inbox. Sign up for a free trial from the industry-leading provider at ConstantContact.com. New problems on 215 westbound. Got an injury accident 215 westbound at the 15 north ramp with emergency crews on scene there. Much more minor accident 95 southbound past Decatur, not causing any trouble, but you're still tapping the brakes a bit heading through the Spaghetti Bowl on 95 southbound. And a new wreck also reported 95 southbound at Charleston, but we're not seeing any slowdowns through there. 15, clear and quiet on both sides, and just leftover accidents on the surface streets. East side Maryland Parkway at Harmon, west side Desert Inn at Lindell, and in the northwest at Buffalo and Gowan. From the KDON 1 Nevada Credit Union Traffic Center, I'm Mitch Kelly on News Talk 720 KDWN.
The KDWN forecast, mostly sunny today, 78 the high, some clouds, 61 overnight, mostly cloudy, and 79 Wednesday. Right now, mostly sunny, 68 in Las Vegas. Your next update at 9:30 or when news breaks, and we're always streaming online at KDWN.com, brought to you by Brian A. Lowe and Associates. I'm John Schaefer, News Talk 720 KDWN.
Hi, this is Kevin Mykert with First Prime Realty Group. Listen to my show, Real Estate Live, every Thursday night on News Talk 720 KDWN from 6 to 7, where we'll be talking about real estate, short sales, and mortgages.
Guns, guns, guns!
The original Las Vegas Gun Show is this weekend at the Sports Center located on the corner of Las Vegas Boulevard and East Sunset. Get your guns, knives, ammunition, survival gear, and more. Buy, sell, trade, or just look. The original Las Vegas Gun Show is Saturday 9 to 5 and Sunday 9 to 4. Get your tickets online now at www.lasvegasgunshow.com.
Listen to The John Brislin Show for the best in late-night political talk Saturday nights from 11 p.m. to 12 midnight. John Brislin hits hard and tells it like it is. The only way to turn the double talk into straight talk. Call in Saturday nights from 11 p.m. to midnight with John Brislin Live.
More live local talk than any station in Las Vegas. News Talk 720 KDWN. 50,000 watts of news and talk. Be in the know when you're on the go. News Talk 720 KDWN is available wherever you are online at KDWN.com. At KDWN.com. Local, national, and international news, plus weather and traffic. All at your fingertips, all online at KDWN.com. The broadcast of information on this show does not create an attorney-client relationship with any of the listeners. Communication between the listener and the hosts of this show will not be confidential. The information provided on this show is prepared for a general audience without investigation into the facts of each particular case and is not to be considered legal advice. The information provided on this show should not be used as a substitute for legal advice. The listener is advised to consult with a qualified attorney on any legal issue they may have. It's time for News Talk 720 KDWN's Legal Hour. Have a legal question? Call now 257-KDWN. That's 257-5396.
KDWN News Time 9:06. Good morning and welcome to the Tuesday edition of the KDWN Legal Hour with attorney Airene Williamson from the Williamson Law Office here in Las Vegas. Good morning, Airene.
Good morning, John. Great to be here again. It's pretty warm outside.
It's nice.
It's nice, and it's great to be here. It's like it starts from winter and straight to summer and nothing in between.
Hey,
so
the beach still having winter the day before spring like they have in the Northeast right now.
I know. I heard they have a storm there.
Mm-hmm.
So, yeah, well, I'm excited to be here because we have a kind of a big, broad topic, and this is employment law. It's such a big, broad topic. And so I've kind of divided it into two parts. One for today and part two for next week, hopefully, in other matters. But today we're going to talk about social media and wrongful termination, which I think are timely topics for today.
That's funny that this is the topic because we just had a conference call last week about social media and our use of social media because in radio, our parent company really, really wants us all engaged and involved in social media. Right. But at the same time, they said, remember, you are representing this company, and no matter what you do, the company is bigger than you.
Exactly. And there are limits to that kind of policies. And we're going to talk about social media today, primarily because we obviously know everyone's on Facebook, everyone's on Twitter, or whatever is coming up. I can't even keep up on these new social media that's coming out. But in any case, 900 million users are on Facebook. And obviously, you cannot prevent employees from using Facebook at work and off of work. And there's kind of a blurring of lines between personal life and coworkers. Obviously, you develop relationship with coworkers, they become friends, they friend you on Facebook, and they start talking about work on Facebook. So the question is, what are the guidelines when you start doing that? And what are the guidelines for employers when they start snooping around your Facebook? And that's what we're going to talk about today.
And as you said, it is so rapidly changing. I remember when MySpace was the big thing, and now no one ever talks about that anymore. So is it important for companies to have a policy regarding social media for their employees?
Definitely. It's not only important, but it's kind of inevitable to do that, primarily because a lot of cases are coming out, primarily disputes between employers and employees when it comes to either termination because of a Facebook post or what have you, or some kind of a disciplinary action that's coming out. And it's necessary to have some form of a policy for a lot of businesses, especially mid-sized businesses, to one, implement a policy that complies with your company policy so it's consistent. And for two, we have a National Labor Relations Board that is sort of overseeing this social media development, and we'll talk about that in a bit. But when you have a social media policy, the general idea is to make it as narrow and as specific as possible so you don't run into problems with the NLRB, which we'll talk about in a bit. Another idea in setting up a social media policy is you want to implement it in a consistent and uniform manner. You can't just implement it on one employee and cannot implement it on another employee, or you only implement it on negative comments, but not on positive comments. That's still kind of interfering with your business activities. You have to implement it consistently.
And a lot of people think, oh, if my business tells me I can't do something, well, that's against my First Amendment rights. But really, the First Amendment is just from the government keeping you from doing something.
Exactly. And that's one of the topics I was going to discuss today is social media. Is that a free speech? Is Facebook free speech? But not necessarily, not in the context of the First Amendment constitutional rights. It's definitely not a free speech in that context. So you are not, as far as First Amendment is concerned, employed by a private employer. It's not a First Amendment issue. Now, we do have regulations that are now implemented. There are not federal or state laws that specifically govern social media because it's such a new area of law. But we have the Federal Trade Commission that is enforcing some social media policy, primarily because if you are, for example, in radio and you're using Facebook, you're promoting advertisement, promoting products. If you're a business using LinkedIn or Twitter, tweeting your products, you have to follow some FTC guidelines. But most importantly, we have the National Labor Relations Board. Now, why are they so important? Well, they're important because they apply to union and non-union employees. They are the largest agency in the United States that primarily govern or issuing rulings on social media. They have released rulings, they have released cases on when you can fire or discipline your employees when it comes to Facebook posts, and you have to follow that. Otherwise, you will run into some penalties and consequences, and primarily litigation and lawsuits when it comes to employees.
Is this something that, because of the speed in which it's growing and changing and is so new to the workplace, is it something where these regulations or restrictions from the National Labor Relations Board are coming out after something happens instead of here's what you shouldn't do, but rather it's, okay, this person did this, and now that we've looked at it, that's wrong, so here's a regulation. No one can do that anymore.
Right, and they're kind of reactive rulings from the NLRB, which is unfortunate, but they are coming out with cases which could be precedent for future, termination issues or disciplinary issues. They are coming out with that. And when it comes to social media, and the reason why social media is important for NLRB matters is for one reason, that is Section 7. And Section 7 creates a ruling that employees in general, not just in social media context, employees have the right to engage in what is called the protected concerted activity. It's a mouthful, protected concerted activity. Basically, employees, co-employees, and everyone in the workplace can talk about benefits, wages, termination, or workplace conditions. They are protected in discussing that. And so it kind of sort of transfers into a social media context when they start discussing that. Generally, you are protected if it's a discussion between two or more employees, and that becomes important when it comes to Facebook posts. If you're the only one individual that's posting and there's no comments, that may not be a protected concerted activity. So generally, you are protected to talk about your workplace conditions on Facebook posts.
A lot of this also seems just to be a lack of common sense with people. You should know as an adult in the workplace what is right and wrong to put out there for everyone to be able to see and read about your business, about your salary, your benefits, whatever. Even if you're discussing it with other people, at least around the water cooler, you're having a face-to-face discussion and it's just the two of you. But on Facebook, it's not just the two of you having a discussion.
I think people forget that. I mean, you have 50 friends, for example, on Facebook, but a lot of people can access to it, even if they're not friends. You have to keep in mind, in social media, there's no such thing as private. Whatever you post there will stay there forever. I think we've discussed that in our internet defamation issue maybe 2 weeks ago. There's no such thing as a private social media post. And you just have to be careful. And when you're an employer, when you're implementing the social media guidelines, you have to look at NLRB guidelines, which I'll go through later. What are the kinds of policies that you can implement and you won't run into trouble with the NLRB? But at the same time, even if you are protected as an employee with all these protected concerted activity that they're talking about, you have to use common sense on what you can place on Facebook. Because as we know, and we'll discuss in a bit, this is a state of at-will employment. They can terminate you for no reason or at any reason whatsoever, and they may not even tell you the real reason why they're terminating you. And that's a hard one to prove. When it comes to social media, especially social media policy, they can use any reason at all, and they may not tell you what the reason is, and you'll just terminate it.
Wow. So that is a lot to think about as an employee, not just as an employer.
Right. And as an employer, when you are reinstating these guidelines and social media policies, the NLRB guidelines has come out with some kind of tips And not just tips, but actually interpretations and cases that you can use. So when you started drafting that social media policy, which you should at this time, especially with all these issues coming out, you should follow it. And number one, employees can prohibit employee rants. Rants on Facebook. Now, we all know that we are protected in talking about wages and conditions in the workplace with other employees. But the NLRB came out with a ruling that if it's just an individual post, for example, and you're ranting about your employee and nobody commented on it, or nobody kind of discussed with you, no other co-employees discussed with you about this workplace conditions, it's just a rant. So that's one of the rulings of the NLRB, which we'll talk about in a bit.
All right. If you have comments or questions for attorney Airene Williamson discussing social media and employment law, 257-5396, the number to join in. Right now, we're going to check in with Mitch Kelly in the KDON 1 Nevada Credit Union Traffic Center.
And this update at 9:15 brought to you by the City of Las Vegas. City of Las Vegas employees are going green, saving more than $1.4 million in utility bills over the last year by conserving energy and water and recycling at city facilities. Visit LasVegasNevada.gov/YourCityWorks to learn more about how your city works for you. NHP was reporting an accident along the Southern Beltway, 215 westbound to go to 15 northbound. They no longer are, and we're not seeing any slowdowns in that area, so that might already be clear. There is a new one south end of town, Blue Diamond on-ramp to 15 northbound, and a pair of minor wrecks on 95 southbound, one past Decatur, one at Charleston. No slowdowns from either of those. New Service Street accident in the southwest, Silverado Ranch at Decatur. West side injury accident remains, Desert Inn at Lindell, and one in the UNLV area, East Side Maryland Parkway at Herman. Next report's at 9:30, and from the KDON 1 Nevada Credit Union Traffic Center, it's Mitch Kelly on News Talk 720 KDWN.
If you have a problem with your teeth and you don't know what to do, pick up the phone and call AQ. AQ Denture and Implant Center has helped over 25,000 people in the Las Vegas and Henderson areas with affordable quality dental service since 1975. I'm Jim Dallas of Beasley Broadcasting. Dr. Maracondia helped me smile again, and he can do the same for you this summer. Whether you need crowns, bridges, dental implants, or an extreme dental makeover, call 565-6000. That's 565-6000 for AQ Denture. Smile again with confidence.
I absolutely hate moving.
You gotta find a guy with a truck.
Back and forth to storage.
Buying gas.
Just have one word. Pods.
Comments from real Pods customers.
The easiest, most convenient, stress-free moving and storage experience.
Much better than a moving company.
The Pods container was delivered to my driveway. I could load it up whenever I needed to.
Pods, perfect for moving or renovation.
Very, very professional.
I use Pods a lot for long-term storage.
Pods came and picked up the container and took it to our new place 300 miles away.
Pods delivers a container right to you. Take your time filling it up, and Pods will drive it to your new place, across the street, or across the country. Or they'll store it in one of their local secure storage centers.
The smartest solution to moving is definitely Pods.
Now, let's talk storage. Right now, use a Pods container for 3 months and get the 4th month free by using promo code FREEMONTH. Call Pods today at 855-251-7637 or visit pods.com for quotes or service availability. Pods, the best moving and storage idea ever.
Some restrictions apply. Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time 9:18. Welcome back to the KDON Legal Hour with attorney Airene Williamson from the Williamson Law Office. You can reach Airene by email if you have a question for her when we're not on the air at info@wlawoffice.com or her office number 608-4072. If you have a question or comment right now about social media and how it affects employment and employment law, 257-5396, the number to reach Airene right here in the studio. So, Airene, what are some rules and regulations that employers should have established? Like what can they regulate as far as an employee and their use of social media?
Well, the NLRB kind of came out with cases that we've talked about earlier, interpretations on cases. And one of the rules is that employers can restrict employees from using commercial marks, trademarks, logos. Obviously, they can talk about the employment and their work conditions, but the employers can put in their social media policy that they cannot use company logos or any trademark secrets. Now, they have to be careful with that because the NLRB, in my opinion, is employee friendly. So they have to be careful with restricting, let's say, I'm going to prohibit you guys from releasing confidential information. Now, confidential information is a very vague and very broad language. People may think that discussing wages are confidential, but surprisingly, if you put it on Facebook and discuss about it, that's allowed. So you got to be careful what you prohibit and restrict. So any logos, proprietary information can be prohibited. Another one that's it's still on the process of being smoothed out is the use of what's called the courtesy clauses when you're an employer and you say, well, you cannot use colorful language or distasteful critiques or unseemly remarks in social media. I've actually seen that in an actual social media policy handbook, and that has been held by the NLRB to be too broad. What is that? What's unseemly remark? That seems to chill the ability of employees to discuss certain things with each other. Another thing is that employees cannot prohibit opinions. Opinions are basically a right of the employees to discuss in Facebook opinions about the company. And then sort of all that discussion are free for all. Those are very fine line that you have to kind of review your social media policy if you have any such things or languages in your social media policy. The other one that is highly probably contested is the employee. Employers have the right, whatever workplace policy that were traditionally in place, such as sexual harassment, prohibitions of threats and violence, or bullying. Obviously, those are the kind of things that they can prohibit in a Facebook post, just as they may prohibit it in a real actual workplace setting. So those are the rights of the employers. And employees, be careful when you post something like that when you are ranting not only about your employers, but also your coworkers, because that can be deemed bullying, that can be deemed creating some sort of this, workplace that you cannot stand, that they actually quit because of your post, and you can be liable for it. So just common sense social media policies that you put in place.
Now, do these policies, and I think this is where a lot of people get upset or think that their employer is infringing too much on what they can and can't do, can it only deal with when you're on social media discussing your employer or your coworkers? Like if we live in Las Vegas, so I go out every weekend and go to the clubs and put pictures of myself club hopping all the time. Well, my employer might not like that I'm out partying all the weekend,
Right.
doesn't like the impression that shows, but I'm not on company time. I'm not discussing the company. Can they prohibit me from doing things like that?
Absolutely not. Absolutely not. Obviously, there's kind of a fine line with it. Obviously, if you're club hopping out of the office work hours, they cannot prohibit you for that. In fact, you cannot have let's say in the context of social media policy, you cannot simply say, okay, you cannot use social media at work, because they do have rest breaks and lunch hours that they can do whatever they want on their own time, and that includes Facebooking. So anything that's off work hours, they can't prohibit, but obviously they can use that as a pretext, that what we call a pretext for firing you. If, for example, if you have a workers' compensation claim and you claim injury, and then I see you as an employer, because it's not private, in Facebook, I see you vacationing or lifting heavy objects or rock climbing on Facebook, and then you say you have an injury, they may, frankly, terminate you for that. But not telling you that I found out about it on Facebook. So those are the kind of common sense things that employees have to keep in mind when they are posting on Facebook.
Is this a black and white issue for employers when they're making these guidelines or their rules and regulations for using social media? Or is there still a lot of gray area out there, as in, it's kind of discussing business, but they're not really discussing business, but they kind of are? I'm going to say that they are because I want to get rid of them.
Well, unfortunately, the NLRB has gone both ways on social media. So they have not provided any clear guidance at all as what constitutes, first of all, one example is that you cannot state that any defamatory remarks about the company. But at the same time, you can do protected concerted activity and discuss workplace conditions. Well, where's the fine line? Well, we don't know because the NLRB hasn't come out with a clear guidance on this. But they have, if you do have a social media policy in place, you got to ask questions about it. One of them is that, are you prohibiting your employees from friending each other? That's one. If you friend obviously you friend people on Facebook, are you prohibiting that? If you're prohibiting that in totality, that's illegal. Are you prohibiting postings at all on Facebook on any workplace or any workplace topics in general? That's overbroad. That's illegal. Any inflammatory, if you say on your social media policy, you cannot post any inflammatory comments about the company. That's broad language that has been deemed by the NLRB as chilling your ability to talk about workplace conditions. So that's illegal. So anything, I think the major guideline is that if it's broad, if it's not specific enough, if you cannot determine, if you're an employee looking at social media policy, I cannot really determine what's right and what's wrong, then most likely it is illegal and it's not going to be upheld by the NLRB.
257-5396, 257-5396, the number to call to join in the conversation about social media and employment law. So we've been talking about employers. What rights do I, as an employee, have?
As an employee, obviously, we've talked about how you can discuss workplace conditions. That's one. Another thing that I think has been coming up lately is what are my rights if I'm an applicant of an employer and I'm applying for this job? Can they look at my Facebook post, which people are doing, obviously, LinkedIn, and kind of conduct a background check? And the answer is they can. On one hand, they can. On the other hand, they can't make a decision based on religion, race, or gender, or disability that they can see from the Facebook post. They cannot decide on that. Whether you can find out that they do actually decide on those is obviously a difficult matter to prove. So, that's kind of up in the air. But if the employer is checking you out, the NLRB has stated that if the employer is kind of snooping on your background, they are now deemed to know about your disability. So be careful with that if you're an employer. My suggestion to my clients is that they don't do the background check until after the interview, or if there's a possibility at all of an employment.
And you hear about this more and more where people are applying for jobs and the potential employer asks for their password so that they can get in and check these things out.
Right. That's been a controversial case, and the trend on that, there's a lot of states now that have actually instated a state law that prohibits employers from asking for passwords. So if you're an employer and asking for password, I would say no at this time, because California, I think, Minnesota, Illinois, they have all placed a statute that actually prohibits that, either in employment setting or in higher education setting. In fact, if you are requesting password, not only is that prohibited, but you also have a cause for invasion of privacy. Nevada hasn't come out with any ruling on that. We are still waiting on that. Even if there's a statute, we don't know. But that's certainly something that's trending right now, and the trend is to prohibit it. So I would suggest no request for password. And really, what do you gain from requesting passwords? You can, first of all, people are voluntarily posting what they have in mind on Facebook, so there's no really reason to get their passwords. So there is nothing to be gained on that. I think the only time that will be considered allowable is if there is a complaint against an employee from another employee, complaints about bullying or copyright infringement, copyright trademark or trademark infringement. That is the only time you can obtain the password, but that has to go through the court through a subpoena.
Libel an issue as well with all of this? Things you might say about your company decides, well, they're slandering us. It's libel. You can't write stuff like that.
Well, in general, that is libel if they know as a person, an employee, if they know that it's an untruthful statement, that's definitely a libelous or slanderous remark. But again, on a social media policy, you cannot talk about the company at all. I mean, as much as we would love to do that I can say to my employees, don't talk about the company at all. That's obviously an illegal social media policy and will not be enforced by the NLRB.
But it seems like that would be the easiest solution to all of this. If you could have more strict rules and regulations so that people knew, cut and dry, here's what you can and can't do.
Well, there are certain things that you can do as an employer, and that is to prohibit when you think you are kind of in a liability situation with another employee, when somebody's threatening violence or defamatory remark against another co-employees or sexual harassment issues. Those are some things you can prohibit. You can prohibit infringement of trademarks. You can prohibit company logos from being used when you're conversing. Those are the kinds of things that you can prohibit. When you also have a social media policy, you can require that the employees sign and acknowledge the social media policy. And you can also require the employees not to say, my opinions represent the company. I'm sure you have that on your conference. All the social media policy conference that we went to, you can prohibit them from saying, I represent the company.
All right, we will be back with attorney Airene Williamson from the Williamson Law Office, Social Media and Employment Law. We're also going to delve into wrongful termination here in Nevada, a right-to-work state. 257-5396, the number to call and join in the conversation, or if you have a legal question for Airene. We will be back after we check in with news, traffic, and weather on News Talk 720 KDWN.
Recently, the U.S. Navy delivered tons of food to hungry people halfway around the world.
But you could help someone in your own community simply by donating a can of soup.
Last week, a Navy doctor saved the life of a total stranger.
Just like you could, by giving a pint of blood.
Right now, a Navy captain is providing guidance to 5,000 young men and women at sea.
While there's at least one young person in your neighborhood who could use your guidance.
Next month, a team of Navy Seabees will change a child's life by building a school in an impoverished area.
You could do the same, simply by volunteering once a week to read at a school right down the street.
The men and women of America's Navy do some amazing things to make the world a better place. So can you. Whether it's by donating food or simply giving time, right in your own backyard. Brought to you by America's Navy.
50,000 watts of news and talk. News Talk 720 KDWN, Las Vegas, the dawn of today's talk radio.
AP Update. I'm Rita Foley. We now know how those 7 U.S. Marines who were killed at a training facility in Nevada died. Several other Marines were injured in the training accident as well. 3 of them are in serious condition. AP National Security Correspondent Sagar Magani.
The incident happened last night at the Hawthorne Army Depot. The Marine official says a mortar exploded unexpectedly, killing 7 Marines and injuring several others. The Marines have now issued a worldwide moratorium on firing that specific type of 60-millimeter mortar until an investigation says it's safe.
The Hawthorne Army Depot in Nevada is an important training facility for troops headed overseas. The official who spoke to us did not know whether the 7 dead Marines and several others who were hurt were in the same firing pit standing nearby for training observation or in a nearby mortar pit. I'm Rita Foley.
9:32 in the KDON One Nevada Credit Union Traffic Center with an update brought to you by the Four Queens Hotel and Casino. No freeway slowdowns right now. The 1HP is working to clear accidents on the Blue Diamond flyover ramp to get onto 15 northbound and a pair on 95 southbound, 1 past Decatur and 1 at Charleston. Newest Service Street accident and injury crash near the Meadows Mall with Las Vegas Fire on scene on Decatur at Meadows Lane. Also one on the southwest, Decatur at Silverado Ranch. West side accident, Desert Inn at Lindell, and an east side crash, Maryland Parkway north of Tropicana at Harmon. KDWN weather, sunny skies and 78 for a high this afternoon. Currently at 67 in Las Vegas. And more of the KDON Legal Hour with attorney Airene Williamson's coming up. From the KDON One Nevada Credit Union Traffic Center, it's Mitch Kelly, News Talk 720 KDWN.
Take a trip back in time with some of the greatest music ever written. Canyon Club inside the Four Queens presents the Jay Bolin Acoustic Retro Rock Show, featuring a selection of hits from the 60s, 70s, and 80s. Now playing at the Four Queens Hotel and Casino.
How safe are your investments? Are you sacrificing good returns in exchange for lower risk? What if you could have both? Installing solar from Solar Universe on your home or business is a great return on investment by saving you tens of thousands of dollars off your electric bills. In Las Vegas, you'll typically see a 7 to 11% yearly return on your solar investment. Where else can you get that kind of a return with virtually no risk? Plus, with the new program from Solar Universe, we will provide the insurance, all maintenance, and a performance guarantee for the next 10 years on your solar system, all included at no extra cost. So if you want a lower electricity bill for the next 10 years, then switching to solar with Solar Universe is right for you. Get a free solar savings estimate online at solaruniverse.com and invest in the guaranteed returns of solar. Get your free solar savings estimate now at solaruniverse.com. That's solaruniverse.com.
Tired of paying outrageous prices for Viagra? Well, we have great news for you. Now you can finally get Viagra at huge discounts. Healthy Man allows you to save up to $500 on Viagra. Why pay U.S. pharmacy prices of $15 per pill or more when you can get Viagra for less than $3 a pill? Call today and get 40 Viagra pills for only $99. This can cost as much as $600 at your local pharmacy. You can't afford not to call us. If you want Viagra at the lowest prices, never pay $15 a pill pharmacy prices again. Get Viagra for less than $3 a pill. Call 800-790-4835 today and save up to $500 and get 40 pills for just $99. Healthy Man is fast, easy, and affordable. Operators are waiting at 800-790-4835 to take your call now. Call 800-790-4835 4835. That's 800-790-4835. Again, 800-790-4835.
Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time, 9:35. Welcome back to the KDWN Legal Hour with attorney Airene Williamson of the Williamson Law Office. WLawOffice.com if you'd like to learn more about Airene, or if you'd like to reach her by email, info@WLawOffice.com. 257-5396, the number here in the studio. Dave held on through the break. Dave, good morning.
Good morning. How are you guys?
Good morning, Dave. How are you?
I'm well. Just a quick question. I've got a complaint with the EEOC right now for failure to provide reasonable accommodations under the Americans with Disabilities Act.
Okay.
Is that something that your office can handle?
Definitely. And that's and we're going to talk about a lot more of it, the EEOC and all that statute of limitations. So, and what are the procedures when you go through that?
There's literally probably 35 or 40 complaints to HR that they failed to act on. Went to the mediation. They violated the mediation, which ended up in another week-long hospital stay and put the employee out on permanent disability.
Okay. Are you an employee?
And it doesn't fall under the undue hardship clause. It would have been a very easy fix.
Right. Are you an employee or an employer?
Actually, it's a friend of mine that's an employee, but I do federal labor law, and I was just trying to help them out a little bit.
Okay. Yeah, that's definitely something we can handle. And if you need any more questions on it, info@WLawOffice.com.
Hey, is there a phone number I can call to set up an appointment for a consultation with you guys to look over the paperwork that we have?
Sure. It's 702-608-4072.
702-608. What was the last four again?
4072.
4072. Okay, I will give your office a call. And should I wait until after the EEOC finishes their final investigation?
It's typically advisable that you call me now so I can see what's going on and where the EEOC at as far as their investigation.
Okay, we can do that. We have everything documented, so it won't be an issue.
Okay, sounds good.
I will give you guys a call and set up a consultation for her. Thank you.
Thanks, Dave.
Thank you, Dave.
Have a good day.
257-5396 if you have a comment or question for Airene. All right, Airene, so we work here and live here in Nevada, a right-to-work state. First of all, what is the difference between a right-to-work state and states that are not right-to-work?
I think the only state that is not right-to-work, I believe, is Montana, if I'm not correct. But most of the states are at-will employment or right-to-work states. Basically, it just means that the employer can fire you for any reason or no reason at all, unless it falls under the purview of a wrongful termination. And that's what we're going to talk about in the second half of the show, is what is wrongful termination. Wrongful termination laws in Nevada basically covers all the consequences and penalties that you as an employer will have if you terminate employees in violation of certain statutes. In Nevada, we follow the federal Wrongful Termination Act, which encompasses the Civil Rights Act of 1964 and the Federal Labor Standards Act of 1938. Those are, and in supplement to that, we have actually NRS, Nevada Revised statutes that specifically governs what are the typical activities of a wrongful termination. One of them is, as we all know, is discrimination. They can't terminate you for your gender or your political beliefs, or, well, not political, religious beliefs, or what have you, and a discrimination, age, and disability under the, as Dave has mentioned, under the Disabilities Act. Those are wrongful termination. And when you think you have a wrongful termination case, that's something that you might want to talk to an attorney about, mainly because, and we'll talk about it in a bit, we have a lot of statute of limitations. It's not just one. Okay, you have 2 years for wrongful termination. Well, that's not how it works. There are statute of limitations depending on what kind of wrongful termination occurred. Either it's because of a workers' comp claim matter, or is it an OSHA matter? They have different statute of limitations, different procedures. And I'm just going to talk about the EEOC. If it's a discrimination matter, if you are terminated in discrimination matter, you have to go through the EEOC first. You can't just go to court and say, I want an attorney, I want to go to court, let's sue the employer. Huh. Right, you can't do that. You have to go through EEOC, have to go through the investigation, mediation, arbitration, just like Dave, our caller, has mentioned. He has to go through that first, and if that's not successful, then it goes to the court. And the statute of limitations for discrimination matter is 180 days, which is 6 months. So if you were terminated and you think it's discriminatory, you have 180 days to file your complaint with the EEOC, and they have to go through that process. And typically you're entitled to attorney's fees if you do win, but there are procedures for Nevada Wrongful Termination Act.
And how do you decide, other than, like, my guess would be I'm disgruntled, so obviously the employer fired me for a wrongful reason, so I need to think of one to come up with to go and fight it, because if my employer doesn't have to tell me and can just fire me when I come in and say, we don't need you anymore, then how am I supposed to know if they haven't, or do you feel like maybe you've been treated differently because of your race or your ethnicity or something, and then have to prove that?
Well, that's wrongful termination, I've got to be honest, are very difficult to prove. And you have to go through the records or your pattern of history with the employer. And typically when they terminate you, they will, to cover their behind, they will typically give you a reason why they terminate you. But that's something they have to take a look at. Any performance reviews in the past, that's something you have to take a look at.
And what if your employer doesn't do things like that, or doesn't keep written records of any of this kind of stuff? You only get verbal warnings, you don't have reviews, so there isn't a paper trail to follow.
Unfortunately, they don't have to do or to keep records of your poor performance reviews. But if you're an employer, I would advise you to have one, because it's going to happen. It's going to come back to you and bite you and say, okay, for all these times I had good performance review, and now because of something that occurred, either I filed workers' compensation claim, or I invoked my FMLA rights, Medical Leave Act, or now I'm pregnant, and a month later I'm fired. But I don't have, as an employer, I don't have any records of any poor performance reviews. I don't have any records of disciplining the employee. It's a good idea to have one, and usually when the employee requests the reason for termination, the employer, anticipating a litigation or possible lawsuit, will provide you either it's false or not. They will provide you a reason, so you can go with that and see what happens. You mean
you got pregnant, you're fired? That's not a good reason?
Right. That is not a good reason, but definitely they will come up with something to cover their behind. So there you go.
All right, you got another call for you. Big John is on the line. Good morning, Big John.
Good morning.
Good morning, John.
Good morning. Hey, I've been listening to my boy there, the legal guy. He's great. I'm new, first-time caller, so I'm a Vietnam vet. Yeah, the question was, if I may interject, that in company uniform, you four or five of the guys and the chicks, Friday night, they want to stop and have a beer, and things get a little crazy, but no police are involved, and the bar decided to call the company. Can you be terminated for that?
Well, are you talking about you went to a bar and you have a company uniform?
Yeah, in uniform. No, it never happened to me. This is hypothetical.
Right. Hypothetically, if you go out after work, still wearing your company uniform, have a little too much, and the bar owner doesn't like the way you're acting and calls your employer.
Well,
yes, that's the one.
Well,
I'm actually a little or no drinker since military.
Okay. Well, first of all, who is the employer? Is it a private employer?
No, city. County.
City. Oh, that's
actually
even more.
Contracted to the county.
Right. Okay. And well, two answers to that is, first of all, one, they can fire you for any reason or no reason at all.
Gotcha.
Second of all, if it's a company uniform, it's not really some kind of a discriminatory where it involves some civil rights act. So they can actually fire you for that. And the reason is you have represented the company by wearing your uniform, and now you're acting inappropriately outside of work, and possibly you are representing the company outside of work without their authority or permission. So yes, they can definitely.
I kind of assumed so. I was telling the drivers that.
Right.
We had a crazy lady, two crazy chicks at a casino actually last year.
Aren't they all?
and I heard about it, and I'm going like, what? I just couldn't believe it. Two ladies. you know, I hear about the guys, the two women. But hey, you guys get rowdy too.
It's Vegas,
All
baby.
Right, thanks a lot. Keep up the good work. We'll be calling again.
Thanks, John.
Thank you.
Bye now.
Yeah, I know, because I have friends in the media who work at TV stations, and a lot of them are assigned station vehicles that are marked, and they can't take them and even park them in a parking lot at anywhere that might give a bad reputation.
Right, and you're using company property. You can't use it for, well, first of all, you can't use it for personal use. Second of all, you can't use that to tarnish the image of your company. So, I mean, and there's really not, there's not public policy involved there, so they can terminate you for whatever reason. And one of them is using the company's image and tarnishing it by drinking off company hours. So those are kind of considerations you have to take in mind.
So does employment at will make it harder for you to prove that you were wrongfully terminated?
Yes. In a way, yes, it is harder to prove it because it's an at-will employment, and it's hard on the evidence issue. Evidence, obviously, you have to show that they have violated your rights by terminating you on grounds that are in violation of at-will employment or an exception to at-will employment. And I'm going to go through that. Well, there are exceptions to at-will employment, and one of that is if they terminate you as a violation of state policy. For example, they terminate you on a workers' comp claim or FMLA or any public policy matter that violates the statutes. Those are an exception to at-will employment.
All right, we will continue discussing wrongful termination. 257-5396 if you have a comment or question for attorney Airene Williamson from the Williamson Law Office. Right now, we'll check in with Mitch Kelly in the KDON 1 Nevada Credit Union Traffic Center.
At 9:45, an update brought to you by the City of Las Vegas. City of Las Vegas employees are going green, saving more than $1.4 million in utility bills over the last year by conserving energy and water and recycling at city facilities. Visit LasVegasNevada.gov/YourCityWorks to learn more about how your city works for you. New wreck in the Northwest. Craig Road off-ramp from 95 southbound occurred about 15 minutes ago, and NHP on scene to cover it. Minor accident 95 southbound at Charleston, not causing any slowdowns. Also, one of the south end of town on that Blue Diamond Road flyover ramp to get on to 15 northbound. There was Service Street accidents on the east side, Nellis, just south of Charleston, and an injury wreck near the Meadows Mall still being investigated on Decatur at Meadows Lane. Next update's at 10, and from the KDON 1 Nevada Credit Union Traffic Center, it's Mitch Kelly on News Talk 720 KDWN.
Want a chance to win a $500 American Express gift card? Log on to our website, kdwn.com, and click on the Amex card. Then give us your opinion on car and truck buying. It will be a nice break to your day, and we would sure appreciate your feedback.
Do you have hidden treasures laying around your house? Hi, this is John Burnett of Las Vegas Jewelry and Coin Buyers. Join me on Ask the Experts every Monday night at 6 p.m. on News Talk 720 KDWN, where we will discover valuables you have that you can convert to cash.
Are you tired of fighting with your water, dry skin and hair, dingy laundry, unpleasant tastes and odors, stained sinks and fixtures? Well, now is the time to do something about your water. Hi, Alan Stock here, and I wanted to make sure I had the best water system available, so I called Connecticut over 13 years ago. My clothes are brighter. I see no more hard water stains, and the water is the best I've ever tasted. As a matter of fact, people who visit our home always ask for another glass of that delicious water. And the amazing thing is, we haven't had any service calls to fix our system. Now, the experts at Connecticut Water Systems really know their stuff and can customize a solution that's right for your home and your family. Now, the Connecticut Water Systems are completely different. They require no electricity, there are no customer adjustments, and they don't use a ton of salt. Connecticut Water Systems also features the longest manufacturer's warranty, and it's designed to last 30 years plus. Your local independent authorized Connecticut dealer wants to make it as easy as possible for you to try clean conditioned water in your home by offering a free trial. Go to kwater.com for more details on their free in-home trial. That's the letter K and the word water. kwater.com and get your trial started today.
Are you missing one or more teeth and wondering, what are my options? Or do you wear dentures and wish for a more permanent solution? Then this message is for you. Dr. Matashmi of Albright Dental invites you to a free dental implant seminar, 5:30 p.m. Wednesday, March 27th. Dr. Matashmi will share with you the many options available today, including implant-supported dentures or partials and single-tooth replacement implants. All seminar attendees qualify for free sedation with their implant procedure. RSVP today, online at albrightsmile.com. That's albrightsmile.com.
LVAC is throwing a week-long party, and you're all invited. The first LVAC Fitness Festival is happening now through this Saturday. The event features some of the best fitness instructors in the world. This group fitness extravaganza is in celebration of LVAC's ongoing commitment to improving the lives of their members and the residents of Southern Nevada. Plus, proceeds from this event will help two local charities, the Lily Claire Foundation and 3 Square. The event is open to the public and designed for all fitness levels. For more information, go to lvac.com.
Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time, 9:48. Final segment this morning of the KDON Legal Hour with attorney Airene Williamson from the Williamson Law Office. 608-4072 to reach Airene at work, or you can catch her by email at info@wlawoffice.com. 257-5396 if you have a comment or question here at the station. Airene, we're talking about wrongful termination at a right-to-work state, employment at will, like we are here in Nevada. Suppose I see something going on wrong at the company that I work for, and I alert authorities or a federal agency or whoever it is I have to alert. I whistleblow.
Right.
And then I get terminated.
Exactly. So on an at-will employment state, there are definitely exceptions to that, and we've talked about it earlier. It's a violation of public policy. And one of the examples of public policy violation is if you terminate somebody in a whistleblowing or retaliatory context. And what are those whistleblowing situations? Well, in Nevada, they have kind of set forth what are the situations for whistleblowing. One example is, again, we've talked about if you file a workers' compensation claim and you got terminated, obviously that's a violation. If you report illegal activities to authorities, that's a violation of a public policy. You cannot terminate somebody for that. If you refuse to work because of unreasonable, dangerous conditions and they fire you for that, another violation of public policy. Or if you refuse to participate in illegal activities, obviously a violation of public policy if you get terminated. And there's different multitudes of statutes that addresses whistleblowing. And one of them, if you report somebody for OSHA violation or if you testify against the employer for OSHA violation, again, that's a public policy violation. So that's wrongful termination.
All right, Eric's got a call here, a question for you about wrongful termination. Good morning, Eric.
Good morning.
Good morning, Eric.
Hi. Yeah, I had a wrongful, well, I feel it was a wrongful termination because I had a lengthy workers' comp situation at a job that I was at.
Right.
And at the end of the case, when they lost, I was trying to go back to work, and they said, well, they had to let me go because there was no available positions. And this was like, I don't know, like the week before, and then the same weekend they were advertising for,
There you go. And obviously they probably gave you some other reason, which is, another reason, or what we call it in legal world, a pretext for terminating you, right? They gave you a reason.
No, they just said at this time I had them give me a letter that said that we don't have any position at this time, and so it took me a while to figure out. But I said, you know what? And I went to the library, and so I said, let me figure out if they're looking for any position at the time. I found out that the same weekend that they should have been giving me the job, they were advertising for it. And I thought that would have been a case there as being blatantly caught, but
right.
So what do you think about something like that?
Well, I think, Eric, you have some substance there. I mean, wrongful termination is very hard to prove. But when it's something that happens, in conjunction with, you said you filed for a workers' compensation claim, is that what you did? And then a week after that, some reason you got terminated, and they say you don't have any position, and now you have a position. Those are what we call circumstantial evidence to prove a wrongful termination claim. I think on that matter, I think you do have a claim on that.
You see, yeah, I feel so because this directly, like I say, when I went back after through all the litigation with the workers' comp, that was like the week. It was like on a Thursday, and I was telling them, and they said, "Well, bring in the paperwork and all that stuff from the doctor's release and stuff like that." And then, so they should have had the position that they were looking for was already open. And then that Saturday, so they told me on that following Monday, they gave me the letter saying that, "Oh, we don't have any positions at this time." You follow what I'm saying?
Right, right.
And the ad was that Saturday, the same weekend that they were looking for.
That's definitely. I mean, those are circumstances that might prove your wrongful termination. The only thing you want to keep in mind is, in a wrongful termination arena, it's especially in EEOC, you have to go through EEOC. There's a statute of limitations that you want to think about. So if this is something that happens recently, you might want to act on it. Or I mean, if you do decide to go forward, you might want to act on it. Otherwise, you waive your right for a wrongful termination lawsuit.
Yes, and and the wrongful termination, what's the statute on that one? Is it still 180, 180 days and stuff?
Well, 180 days for discriminatory, 2 years for wrongful termination, depending on the circumstances. So I have to see it, I have to look at it, and as soon as possible, so we can figure out if you've blown your statute of limitations for one. So that's something that really you have to talk to an attorney about.
Right.
Okay.
Okay. So your number is 608
4072.
608-4072. Okay, thank you.
Thank you, Eric.
Bye.
Thank you very much.
That's an interesting call because there's actually a Chicago case that I've just read 2 weeks ago. The employee basically filed for an workers' compensation claim a week after he was fired. But it's a little bit different circumstances because the EEOC actually held in favor of an employee. And what happened with that is that the employee went to a workers' compensation claim. He took some leave of absence because of his injury, but his medical doctors gave him a release to go back to work. And his employer kept calling him, saying, come back, we have a position for you. So it's kind of a different on what Eric has said. We have a position for you. We would like you to come back. We need some help. And you already have a release. Why can't you come back? And he basically just ignored it. And the EEOC held in favor of the employer. Because in that case, there is no motive for retaliatory. They basically saved his job, and they kept calling him, and he just ignored it. So those are the circumstances you want you want to think about when you have a wrongful termination case.
You've talked about family medical leave. I understand, especially women take it when they are having a baby, take that time off. But I know of men who take it as well to be at home with their wife after the baby. And they're the ones that seem then to get into trouble, or their job mysteriously vanishes while they're off. Their employer says near the end of their time, we don't need you anymore. Or like in Eric's case, we don't have a position for you now that you're coming back.
Unfortunately, for employers, FMLA has to give equal rights to men and women, especially one example is pregnancy. Actually, men can take leave on a pregnancy situation. So the employer has to provide, it doesn't have to be the same position, but it has to be the same pay. So those are the kind of issues that you want to take a look at. And if they terminate you for that reason, that you might have a case for a wrongful termination.
What if I just think my employer doesn't like me and that's why they terminated me?
Well, actually, there was a newspaper case on this, and I just read this, and I don't know if you read about it, but the woman was terminated because she was attractive.
Yeah,
I think that was maybe 6
That's
months
my
ago.
problem. My boss, I'm afraid he's going to fire me because I'm too attractive for the radio.
I'm too attractive, and unfortunately, I guess the only case you have on that is maybe discrimination on gender. But if they don't like you and there's no public policy violation and the employment is at will, meaning you're not in a contract or a term, they can terminate you for any reason or no reason at all. So, I mean, those are the kind of things you want to take a look at.
This is, again, like everything we've discussed when you're in here, Obamacare or what have you. There's a lot of information here that I think employees probably don't know what their rights are, because who is really looking through all this stuff when you're getting a job, especially in today's economy? I got a job. That's all I care about. I don't know all the nuances, the rules and regulations of what I'm entitled to and not entitled to if something would happen.
Right. And a lot of employees are strapped because what we call leverage, they don't really have a leverage to fight against their employers. They're just happy to have a job, and they'll do anything to keep the job. And so, I mean, really what it boils down to is for employers and employees to have a set rules and regulations, have a clear handbook of your employment rules, enforce that uniformly, keep records for both employers and employees of what has happened. If you have any reviews at all, if you have poor performance reviews, or if you have a meeting with your employers, it's a good idea to keep track of it. And if you think a meeting, for example, for a disciplinary action, is going to result in some kind of a termination, you do have the right to have a coworker there as a witness or a union representative. In some cases, in fact, they would call me as an attorney to be in a meeting if it's a possible criminal charge, like a theft or a property loss. So keep in mind those policies, just implement it uniformly and keep records. That's all I ask of clients. Keep records. If you don't have records, it's hard because wrongful termination is a very hard thing to prove for the clients, for employees especially. So
doesn't that just make your employer angrier if you bring someone else to the meeting with you to act as your witness?
Exactly. And you know what? I always tell if it's an employee client, if it's possible at all, I don't bring attorneys there. Because attorney at some kind of a meeting kind of represents an aggressive stance. And if you just want to talk about it and want to resolve the issue, you might just want to have a coworker there. And usually employees or employers will have a supervisor there anyway. So,
all right. Attorney Airene Williamson from the Williamson Law Office, 608-4072, or you can reach Airene by email at info@wlawoffice.com. What will we be discussing next Tuesday?
More employment law, and because it's such a broad topic, but basically non-compete agreements and contracts.
That's big in this industry.
Yeah, definitely.
Well, I can't wait for next Tuesday.
Employment law.
All right. Thank you for joining us on the KDON Legal Hour. Ray Lucia coming your way next on News Talk 720 KDWN. Having trouble telling time when your alarm goes off in the morning? Need to have someone across the table hold the menu for you when you eat out? Do you need the Reader's Digest big print version of everything? KDWN's John Schaefer here, and that used to be me once. That was until I had a LASIK procedure at LASIK of Nevada. Dr. Rothman and the staff of LASIK of Nevada have performed over 50,000 LASIK procedures on athletes, celebrities, and regular Nevadans like me. Dr. Rothman takes the time to sit down and explain the entire LASIK procedure to you. It really makes you feel comfortable prior to the procedure. Don't like wearing those glasses or contacts? Then call LASIK of Nevada right now to set up your free consultation. 636-2010. That's 636-2010. You know, today's LASIK can be safer and more comfortable than ever before. In fact, the FDA says the advanced technology used by LASIK of Nevada is safe and effective. So what are you waiting for? Put on those glasses you hate and give LASIK of Nevada a call today, 636-2010, 636-2010, and set up your free consultation.